the first to know Nsem-Pii TV.
Breaking news abeka Nsem-Pii TV nsa. Na krata damanimu kakraka enyumre. Uhwe krata nimu a ensem ewom ni bi ni se. In the Superior Court of Judicature, in the Supreme Court of Ghana, Accra, nipa the signature ehye krata yase ya ne stamp sesi so the Chief Justice Yamame Gertrude Tukomu na criminal appeal number J13 date sheho ye 8th August 2024 the Attorney General Godfrey Yabadame versus the state way appeals document Supreme Court acknowledging receipt of it free the office of the Attorney General appeals document case this is the appeals document on the case involving Dr. Kessel Forson and businessman Richard Jakpa. Now, on the 30th of July 2024, and at the Court of Appeal, it delivered a 2-1 split decision in favor of Minority Leader, former Deputy Finance Minister Dr. Kessel Forson and businessman Richard Jakpa, equity of no wrongdoing in the 2.37 million euro ambulance case. Nipa imi file a case of no submission. In that ambulance case, High Court Botugui established a prima facie case. The case no ma Dr. Kessel Forson kwade close the case. Ni begina Richard Jakpa. But now Oma the kind of file an appeal. The Court of Appeal. So still submission of no case in the appeals court to sign with him. So mu boni bi omaye. And so mu jina court. Na yatoto to omano. And no na Court of Appeal no court transe. Judges miensa court transe. Emu mienu ejitu mu se no kre. Omo wi mu nyina dia dance say submission of no case ni was se gina. Na High Court no ye mfonso. Enti Dr. Kessel Forson and Richard Jakpa inform hunkodi. The Attorney General Emma Ghana for nyina say case this is not the end of it. Obeko appeal. Na appeal na okono. He is moving straight to the Supreme Court. No, there's some not down woman. Now, what say at the Kudientia answer the acquittal of Kessel Forson and the Richard Jakpa answer say they hold the test of time because ruling no awon so akenkan bi no enfonso bebrebe e wo ho na said the beya obeti case na see making kind the appeal document the akyerɛw ma said the beya obehunu said the case ni si ko na si ba no nti no me say to me boase na ma summarize the entire decision of the Court of Appeal ye 2-1 the obia kan ye ntia ne omu gina so e rule say submission of no case no enyina na Dr. Kessel Forson and Richard Jakpa emfa no nkodi any statement Attorney General and so edia share ne appeals document mo no so kire say Supreme Court so hwe so na sa appeals court ruling no ono so yen set no aside say the bia be hu say the case no esi echo. Now judge for me and son omo tenase e wo the appeal case no so no 1 Justice Kwaku T Akabuafo. 2 Justice Philip Bright Mensah and 3 Justice Alex Poku Echampo. These were the 3 appeals court judges. Omo a rule on the submission of no case and the possible and answer the acquittal of Dr. Kessel Forson and Richard Jakpa. Judge near will declare Justice Kwaku T Akabuafo. Nsem now kind in Nana Mabon Tofan or say based on my analysis and in fidelity to the law, I am of the opinion that the appeals filed by both the first and third appellants should succeed. In the result, I would allow the appeals and the ruling of the trial court dated March 30th, 2023, calling on the first appellant and the third appellant to open their defense in respect of the charges in count 1 and count 5 hereby set aside. Also, The call on the third appellant to open his defense in respect of the charge in count 3 set aside. In their place, an order upholding the submission of no case entered for both the first and third appellant in respect of those 3 counts in the charge sheet is issued. Consequently, both appellants are hereby acquitted and discharged. Reasons for Justice Philip Bright di nyina na yepe nti meka ni nyina bom na makan baako. Now, they both made and Justice Philip Bright Mensah both made some conclusion, including the fact that the prosecution, which is the Attorney General, did not establish a prima facie case against Forson and Jakpa, and therefore the High Court erred by upholding the argument of the state. According to Justice Kwakuti Akabuafo, Justice Philip Bright Mensah, the Attorney General, and to me, I established a prima facie case. Say they rejected the case of the Attorney General that Forson issued the letters of credit without the authorization of the then Finance Minister, Nsem-Pii, noting that evidence adduced by confessions from both Forson and Nsem-Pii indicate that his boss, Nsem-Pii, was very much aware of Forson's actions, and that he, Nsem-Pii, gave Forson the permission to issue those letters of credit. And the judge for me, the kind say Attorney General, say Forson issued those letters of credit without authorization. According to Judge Simienu, and yes, sanity. And according to Amoka Sane say, Forson no one can say the dance here or court to say, and then the 2 may soon sign. Sansona said, Tekpeyana or your finance minister, or no so Forson friend as a witness, no, or no so be dear dance here or court to say, or no, and the man, Dr. Casey, Forson, to me, say on issue those letters of credit. And until on J, you will say, Tekpeyana no 2 munu precope. So you cannot come to court and say that Forson acted without authorization. This is according to the 2 judges. Ebiomo say, to succeed on the charge that the first accused acted without cause and authorization, the best evidence to establish it was for the prosecution to have invited the substantive minister, Honorable Nsem-Pii. Having regard to the evidence, it was done on his blind side. We are of the considered opinion that Nsem-Pii was a material witness whose evidence would have decided the case one way or the other. Failure by the prosecution to invite him to testify that he did not authorize Forson was fatal to the case of the prosecution. For the law is well settled that if there is a vital point in issue and there is one witness whose evidence would settle it one way or the other, that witness is a material witness that ought to be called to offer evidence. There is that evidence on record in our present case that in the course of investigations into the matter, Honorable Nsem-Pii is said to have volunteered a statement to investigator, prosecution witness 5. In this case, that seems to suggest that the request for the establishment of the LCs was done on behalf of the Ministry of Finance. For purposes of clarity, we reproduce excerpts of the statement, that is Exhibit 5, upon receipt of the Attorney General's opinion. Ministry of Finance proceeded to establish the LC. The letter noted that this was a valid contract. By this voluntary statement to the investigator, it means that Mr. Nsem-Pii was very much aware of the steps the first accused took in requesting the establishment of the LC to avert the imminent action against the government of Ghana for breach of contract. And this advice was given by the Office of the Attorney General then. Now, there is no iota of evidence on record to show that if indeed the letters the first accused wrote were done on his bland side, Mr. Tepe repudiated the same or he queried the first accused for what he did. It cannot be lost on this court that it is the Ministry of Finance that has the sole power and or duty to request for or authorize letters of credit to be established on behalf of government ministries and departments. The prosecution witness 4 in his evidence to the trial court as appearing on admitted that that was the right procedure to follow. In the result, we roundly disagree with the learned trial judge to have rubbished or rejected Exhibit 5, saying that the author of that statement has not been subjected to cross-examination. I think that the lower court fell into serious error, occasioning a gross miscarriage of justice to the first accused because his duty is only to raise doubt in the case of the prosecution. On the authorities, if there was a doubt in the case of the prosecution, it shall inure to the favor of the accused. Consequently, we allow the appeal on count 1. Enti omu nyina so a omu di ejina so nyina ne se Tepe ejitu mu se ono ne ma Dr. Kesila to Forson ntumi. Na se wani antumu pa krata bia no hono mu ekire se Tepe ekweri ato Forson e wasa na mo na wotu ye no. Krata bia no se dia dance se Tepe e reporto ato Forson wasa na mo na wotu ye in the issuance of those letters of credit. Hence, it means that said Tepe was fully aware and fully in support of Anamono Ato Forson too. And in the Ministry of Finance, it is the substantive minister that is held responsible for any other payment made. This is said Tepe and to me and deny dia. It's just Ato Forson and Yabonibia. Tina was a prosecution in fresh said Tepe. Now said Tepe to me back catch the court to say, the Ato Forson ye no, onim nti omudo mususu se judge ni awote adwamu mfonso e wo saade no enna the other judge ono ejina mu no enso kire mu a o dissented to the views of the majority or rejected the submission of no case by Ato Forson. On the High Court decision to establish a prima facie case is absolutely in favor of that decision, because according to Justice Alex Pokwe-Champo, Sir Takpan Swan to me and provided evidence be a chira say or no, and my daughter Kesila to Forson to me. Every single letter of credit, involve payment piano, nipa ni signature ne chassis, your Dr. Kesila to Forson. According to Justice Alex Pokwe-Champo, letters of credit in one day the issue, and 1 month the issue. Now a year over a period of time. Until all those period of time, where was the substantive minister of finance in Tia? Nina Ato Forson and a Nsem-Pii. On the other, we are fully in support of the High Court establishing a prima facie case. It is say ankasa na appeals court no ruling no na etie. Now osha the learned attorney general Yewra Godfrey Yabodame appeal no also file a was say the argument in say the Court of Appeal misdirected itself and committed error of law by ruling that a prima facie case has not been established against Ato Forson and Richie Jakpa. Enti Yewra Attorney General Suchirimu Appeals Court 1 omo misdirected omo And almost a year from swore and ram from swore say, or much I say. Attorney General, any High Court, and to me establish a prima facie case and frontier at Forson and Jakpa. Because according to the Attorney General, a new way and then the Attorney General and Justice Efiase was a butchery. And to me establish a prima facie case against these two accused persons for them to open their defense. Bako and say on 7th of August 2014, letter be a year signed by Forson, Echo Bank of Ghana. Yana a instructed Bank of Ghana say omo establish irrevocable transferable letter of credit. Ya ne sika ehyeso eye 3,950,000 euro. Ya nipa ne sika no kwama no eye Big C General Trading Limited. Jumedi ne sika no kodie eye payment for ambulances for the Ministry of Health. And Attorney General Sanchirimu to me krata yama letter of credit in resort to in payment no and so echo on the 10th of August. Ya sika ye tua ye no ankwa ye 3,950,000 euro but ye 2,370,000 euro. The purpose na a supply of vehicles by Big C General Trading LLC. Vehicles in a buy no. They didn't meet the description of an ambulance. Yeah, a fact clearly established from evidence on record accepted by all parties. All parties, say, the Attorney General, the first accused, Forson, the second accused, Dr. Sylvester Enimana, the third accused, Richard Jakpa, all parties on court record, Ejitumu say, the vehicles that were shipped didn't meet the description of an ambulance. This is according to the appeal of the Attorney General. Now, again, court on Krata Sanchirimu say, the terms of the contract governing the transaction was violated by Dr. Kesil Forson due to his criminally negligent and unwarranted stance. That is the effecting payment. And Attorney General Chirimua and Krata free the office of the Attorney General. Yeah, Ministry of Health, any Ministry of Finance and Social Sieno. Contract nature say, yen to yesika bia kusi say, ye be ye inspection yamu say, de yen say kano, ye de na ye pe. But in this case, letters of credit were established and metamorphosed into payment without Ghana getting value for money, with Ghana receiving defective vehicles. Someone can a matter of public record. Now, all parties didn't dispute the fact that Yetuasika and some ownership ambulance and India Bamia Behunu say the ambulances and the vehicles are defective, not fit for purpose. And according to the Attorney General, and no enema, Justice Efiase was a rebuttal, Ejina also said, the Ghana to me Tuasika 2,370,000 euro. Na ye dia kwa kra vehicles dia bon man yimu. Na nipa wo krai. Aban asue ya e de vehicles ne ba yadwuma. Ena afei aban asue ya hwesika semso. Ghana ambulance service nyina agya to mu se cars no ebeduru ye no. Ye tuasika de enso dwuma die sese ebedi ne entumi ni dia. Then people will have to answer questions as to why payments were made to the tune of 2,370,000 euro. Meanwhile, those vehicles could not serve their intended purposes. And the High Court judge, Justice Efiase was established a prima facie case because of minor aboka. And The first accused was asked to establish to open his defense because every single letter of credit that went out there was signed by him. There is no record, both written or any other record, that can back the claim say Jakpa and a man to Forson to me, other than Nsem-Pii no akasa be gina court kan as a witness to the first accused. This is according to the Attorney General. Nsem-Pii and a man, the High Court, led by Justice Nsem-Pii, established a prima facie case. Indeed, say appeals court to say a prima facie case was not established. It means the Court of Appeal misdirected itself and committed an error of law by ruling because there was enough evidence. Yeah, the High Court, led by Justice Nsem-Pii, established a prima facie case. And all these evidences, letters of credit, the actual contract between the Ministry of Health and the Ghana's Parliament, big senior Nina, is in the possession of the Accra High Court. The interesting times ahead. You ever heard someone a be free Supreme Court and so but until then, the breaking news is that every year the Supreme Court of the land has acknowledged the receipt of appeals document from the Office of the Attorney General appealing the decision by the Court of Appeal on the acquittal and discharge of Dr. Forson and Jakpa in the 2.37 million euro ambulance case.